This is an alarming development and a staggering attack upon free speech, where the CPS appears determined to establish a blasphemy law in the UK, essentially by the back door, whereby if someone criticises a religion and someone else attacks them for it, then the person criticising the religion is the one committing the offence. The CPS says that this is because their conduct was disorderly. So that I do hope you'll stick with me in this video because everybody needs to hear this. You may remember this chap here who was prosecuted for burning the Quran. Now, I make a sweeping caveat here. I don't agree with burning a religious text, but that doesn't make it a crime. I've explained that before and I stand by what I've said. It is not a crime. It should not be a crime. And just because someone attacks you for it doesn't make it a crime. It is part of the expression, your personal expression of thoughts, and you have the freedom to do so. But you may remember this guy was originally convicted in the magistrate's court. Now I can jump over to this one here, this original one. This was the judge's original reasoning for convicting this man, Hamit Coskun. The court said, among other things, the interference with his freedom of expression is necessary in this situation to prevent public disorder. So the court said it was necessary to interfere with his right to the freedom of expression to prevent public disorder. The judge said the consequences of his provocative behaviour were that serious public disorder did break out, because you remember he was attacked for it. The judge said the effect of criminalising his behaviour is not to punish him for their criminal acts and would not be an encouragement to others to respond in a similar way. The aim is to prevent it happening in the first place. Let's read that again. The effect of criminalising his behaviour is not to punish him for their criminal acts and would not be an encouragement to others to respond in a similar way. The aim is to prevent it happening in the first place. That is, with great respect, is such a flawed logic that it should never have been the decision. What is he effectively saying here is that we're convicting this guy not to punish him for what he did, nor to encourage other people to attack him, which is what happened, but we are punishing this guy, we are criminalizing this guy for burning the book so that we prevent him from being attacked by other people. Now, that just doesn't make any logical sense to me. And accordingly, that was appealed to the Crown Court. So that was heard, just to explain very briefly, that was heard in the Magistrates' Court, and then it was appealed to the Crown Court. You have an automatic right of appeal to the Crown Court from the Magistrates' Court. So that was appealed to the Crown Court, and the Crown Court overturned it. And here we have some of the reasoning for that. We have essentially a lot of discussion as to what he did and how provocative his behaviour was. He was, firstly, it was not aimed at any person. It was outside the Turkish consulate. It was clearly a political protest. He was by himself. It was in daylight. It was of short duration. The reaction of other people was not determinative. You know, people just walking by and didn't really pay much attention to it. There is no sense, the judge said, that any of the passers-by or spectators felt sufficiently alarmed to hurry away or even cross the road. They see a man by himself on a fairly empty pavement who shouts and sets fire to a book. And the judge said at the risk of repetition, their casual reactions to his conduct were not determinative, but they are telling. So this is going to be important for what I think of the CPS appeal, which I'll tell you about in a minute. I think this is very indicative. Also, the laws that already underpin free speech, which I'll come back to a bit later in the video. So the judge said at the risk of repetition, the passers-by's casual reactions to his conduct were not determinative, but they are telling. In other words, no one was really bothered by this, apart from the guy who obviously came out and attacked him. Bearing in mind, the original court said, we're criminalising this guy so that we prevent other people from attacking such people in the first place. It just doesn't hold logical sense to me. With great respect, it just doesn't. Judge then said, both men may well have felt insulted, but that's no longer a basis for a Section 5 offence. Kadri, the other guy, may have grown very angry and his threats to kill, then procuring a knife, because this was the guy, remember, that he threatened to kill him. He ran away. He came back with a knife to attack him and did attack him. Before attacking would tend to suggest, but the judge said being angry is not the same as being harassed, alarmed or distressed. So the judge said he didn't accept that this guy was harassed, alarmed or distressed. Judge said the court should be wary of allowing the criminal reaction of one person, the guy who attacked him, to make a criminal of the other one and exercising his right to free speech. This is all about free speech and whether or not we have blasphemy by the back door. More about that in a second. Judge goes on, it follows from our consideration of the evidence that the prosecution have not succeeded in making us sure that the defendant's conduct can properly be found to be disorderly or that it was within the hearing or sight of any person likely to cause harassment, alarm or distress thereby. That, in a nutshell, is what I think the High Court will ultimately decide and say, well, we agree with the judge. That's his judgment. We're not going to overturn his judgment. The CPS are arguing that it's an error of law. Well, I don't think it is. I mean, I think the CPS really are arguing that they wanted a different decision. I think the High Court's going to say, well, no, this was a judgment on the facts. The law is the law, and this, as a matter of law, cannot make out an offence because it's no longer there in Section 5. And the judge made a judgment at the Crown Court with the assistance of the two lay magistrates. We had Mr. Justice Benathan and Miss Guest JP and Mr. Graves JP that made up the bench for the Crown Court appeal. Now, you might also remember that I did this video here just as a bit of more background on this. A lot of this started with the push for a blasphemy law in Parliament. Allow me to mute myself and remind you of this little snippet from pretty much a year ago. Listen to this.
Thank you, Mr. Speaker. November marks Islamophobia Awareness Month. Last year, the United Nations Human Rights Council adopted a resolution condemning the desecration of religious texts, including the Quran, despite opposition from the previous government. Acts of such mindless desecration only serve to fuel division and hatred within our society. Will the Prime Minister commit to introducing measures to prohibit the desecration of all religious texts and the prophets of the Abrahamic religions?
And I went into great detail in that video as to why this absolutely should not be allowed to happen. Because the prohibition of any, desecration, he was obviously referring to the burning of text. And as I've mentioned, I don't agree with the burning of texts, but he was talking about desecration in a general form. At least it could be interpreted to be a general form, and that's the problem. And so this absolutely should not be allowed to happen because we should not have a blasphemy law. We got rid of those a long time ago. And anything that sort of shoehorns this into an offence of blasphemy is exactly that. It is blasphemy by the back door. And now the CPS appear to want to appeal this decision by the Crown Court to overturn his conviction. So as you'll read here from the Free Speech Union article, the CPS is arguing that what he did was disorderly, not because it was blasphemous, but because it was an act of desecration that provoked those who see it as blasphemous, namely Muslims, to commit acts of violence. They cite other instances where Quran burning has led to violence and argue that because of this, it is not something the law should allow. And so effectively, they are arguing for an offence of blasphemy. They are saying that the law should not allow this act because other people of a faith are angered by it and they might then commit an act of violence, and therefore the law should not allow that original act in the first place. Now again, I'll reiterate, I don't agree with the act of what he did, but that doesn't make it a criminal offence. It is his right to the freedom of expression, and that is not just speaking of words, it is expressing your views, and he was doing it in political protest in front of the Turkish consulate. And so as Free Speech Union says here, this just cannot be correct. Not only is the CPS argument to assume the worst of those who follow Islam, implying that they are incapable of respecting others' right to the freedom of expression, but it invites religious extremists of all types to attack anyone that they believe is breaching one of their blasphemy codes. So it would underpin anyone attacking someone, committing some sort of act that they see as blasphemous, and thus the law should criminalize that person for it, even if they are exercising their freedom of expression. And then the argument follows, which I agree with. The Free Speech Union says all they need to do to shut down speech they don't like is to violently attack the speaker. So then the CPS argues that that shouldn't be allowed. And then the speaker would be the one prosecuted for committing the religiously aggravated public order offence. And that absolutely cannot be right. And if there was any doubt, we can come back to the Scotto and CPS case, which already went to the High Court. It already discussed free speech, and it already made it absolutely clear, as in this highlighted paragraph here, the prosecution argument failed entirely to acknowledge the well-established proposition that free speech encompasses the right to offend and indeed abuse another. The judge appeared to consider that the criminal conviction was merited for acts of unkindness and calling others names, and that such acts could only be justified if they contributed to a proper debate. And so again, with that in mind, to remind you, the CPS argument in this case is that his act was disorderly, not because it was blasphemous, but because it was an act of desecration that provoked others who see it as blasphemous to commit acts of violence against him. And then they cited other sources where that action led to violence because someone else attacked them for it. And that just cannot be right. It absolutely, fundamentally cannot be the case that if you exercise your right to the freedom of expression and someone else is upset by it and they attack you for it, that your act is then criminalized and therefore should be outlawed. And if that, as in this case here, happens to be something to do with religious text or anything to do with religion whatsoever, that makes it an offence of blasphemy. However you structure that, it makes it an offence of blasphemy. My prediction, I hope that I'm right, but my prediction is that the High Court will say two things. Firstly, the judge in the High Court was making a judgment as to how the facts apply to the law in that case and that they will not interfere with it. And secondly, I think the court would rule that if it was wrong about number one, that number two, that it would refuse to criminalize the act of a person exercising the right to the freedom of expression just because it invoked violence from someone else that consider their actions blasphemous, because that would amount to a blasphemy law. But I think more generally, the court may not reference it as blasphemy. The court might likely just say that it will refuse to, or it'd be wrong or unjust to criminalize that action just because someone else attacked them for it. That is not acceptable. Just as in the Epping Hotel case, the High Court refused to grant the injunction on the basis that they said the police should deal with the fallout, and it should not be an argument that they get this injunction because violence is likely to ensue. Effectively, you can't have this both ways. I think that's the way the court will come down. So whilst it's a very different case, ultimately was a possibility that the hotels being used in that way might result in further protests and violence. The court said that is not really a consideration. It's for the police to deal with that. Likewise, in this case, if someone is exercising the freedom of expression and a lot of people are upset by it, it's for the police to deal with that and for those people to be criminalized for their attacking this person, not the person exercising freedom of expression. Otherwise, we shut down free speech and we effectively have a blasphemy law in the UK. That, I suggest, is not going to happen unless it's absolutely written in law, in which case it would probably later be repealed by another government, because I don't think a subsequent government would allow that to stand. And we've seen this happen over the last decades. We've seen a law brought about and then repealed very quickly. Just like we had the digital ID, we had that brought in and then it was repealed again. So I think if it did come in by legislation, it would be repealed. But I think the High Court will refuse to rule that this was an offence on two bases. One, that the judge in the Crown Court, with the assistance of the two magistrates, made their decision and that they will not interfere with that judgment. And secondly, that it would be wrong to rule this action criminal. Those are my views on that. And just for completeness, the BBC reports that the CPS made a statement that there is no law to prosecute people for blasphemy, but added that their case remains that Hamit Coskun's words, choice and location of burning the Quran amounted to disorderly behaviour, and that they've appealed the decision and the judge has agreed to state the case for the High Court to consider. And against that statement, the National Secular Society Chief Executive, Stephen Evans, said in a statement that this appeal marks a renewed assault on free expression by prosecutors. He says the CPS seems determined to establish a blasphemy law by the back door. Their approach is effectively treats those who are targeted with violence for offending religious sensibilities as the wrongdoers. This is an alarming inversion of justice. If this stance is allowed to stand, extremists will be handed a veto over free expression, and the principle of equality under the law will be seriously undermined. And for what it's worth, I agree with that. I think if we criminalize person A because person B attacks them for what they say, that is a destruction of free speech and a reinvention of blasphemy laws by the back door. But let me know your thoughts and comments below. I understand this might split the room, but as always, thank you for watching.